Hi, hello, welcome to Telugu NRI Radio Facebook Live, Wednesday on immigration by Garrison Law Firm, Burgos and Garrison Law Firm. Hey, it means we took the long break. Last 3 weeks, we did not have a show due to the Christmas holidays and New Year's. We are coming today with the latest updates and interesting points, and we can discuss more points and information on the immigration system. What is going on these days? Today, I think uh, Trump had the impeachment, so I don't know what is going on here. So Lucas will give the more information, the latest immigration administration process, Trump administration, and we will get the new uh, points from the Biden will take oath on January 20. So we'll get the more information. What will Biden do after once take the administration? So we welcome to Lucas. Hi, Lucas. Welcome to Telugu NRI Radio.
Hey, Venkat. How are you doing? Happy New Year.
Thank you. Happy New Year. Thank you very much.
Glad we're all safe and back at it. Want to welcome all of our viewers and, everyone paying attention to this. It's going to be an exciting new year, and hopefully we'll have a lot of change coming through.
Yes. So how was the Christmas and New Year?
It was good. It was, a good break, and hopefully it was with you as well and your family and everyone else who's watching. And, hopefully we started off the new year on the right foot. Except for any issues that might have happened at our Capitol, hopefully this next year goes smooth as well.
Okay. So, Lucas, just we had the recent, even the Trump had only less than 10 days, but he brought the new rules. He implemented the new rules. Can you give some more points on that one? Who are affect? Maybe these recent changes will continue to in Biden administration, or Biden will have any chance to get back these rules?
Well, that's a very good question. And so it's a complex answer in the sense that it depends on which rules that we address and refer to. And I just want to start off, I think, since you put the announcement out late yesterday, the president has a proclamation about people who need to travel. Okay, so any foreign traveler trying to enter the United States has to show that they have a valid COVID-19 vaccine. So I know there's a lot of people, I've spoken to many of my clients here where maybe their parents have expired or there's some other emergency and they have to travel. And so now it's just one more hurdle that we have to navigate where we need to have the vaccine. And we don't really know, if you travel back to India and you're able to get a vaccine there, is it the same vaccine that would qualify as like a Moderna or the Pfizer vaccine to qualify to come back in? So we're still monitoring that closely. And that's something that I would imagine that Biden, once he's president, that's a movement with numbers of people being vaccinated. That's first and foremost. Second, we did have, I think we spoke last time about this new rule for the H1b Cap. And that rule did go into effect. And what we're referencing here is how Trump wants to design the lottery system to make sure we, select people who are paid the most. And so this doesn't necessarily mean that it's the best or brightest. It doesn't mean it's the most needed. It doesn't mean anything other than random in the way the selection is made. Now we're looking at who's being paid the highest wage, or the wage level 4 versus wage level 3, and it's not like Biden can just come in and reverse this rule. With this rule, the option is still there for USCIS to implement. And I reference this because, last year was the first year we had the new registration process. Employees use their passport number, date of birth, if they were a master's cap, regular cap, so on and so forth, to be selected. And then after they were elected, we have permission to go ahead and file the LCA. And at that point in time, we would know the wage offered and things like this. Now, with this new rule, I don't know if there's going to be enough time or if there's even been any work done to implement this new rule within the current system. So what this means is, if the new administration wants to proceed utilizing this rule, we would probably have to go back to paper filings and be selected in a lottery that way. We keep the same system that we used last year, and I'm sure there's going to be some lawsuits or some other things happen between now and the year after, it's fiscal year 2023, before we have any commitment to this rule. But it's not erasing the rule or writing a new rule to get rid of it.
Okay. Lucas, sorry, it went in between. The audio is fluctuating. Just have a look. Is any internet issues at your point?
Can you hear me fine?
Yes.
Okay.
Yes, Lucas, you given more important and interesting point on immigration system. We can go for the step by step or point to point. First, we can discuss about the travel ban. He extended to the until March 31st. The same rule will apply what it was in December 31st, or did he add any points to ban the travel or the visa suspension until March 31st?
So pretty much everything on the ban itself, addressing specific non-immigrant visas and certain green card petitions or applications, it remains more or less the same. Now, there's been a few lawsuits. Most notably, there's one with the U.S. Chamber of Commerce that allows their members to be exempt from this ban. So there's a court order, and we've been able to, send employees who work for companies who are members of the U.S. Chamber of Commerce, along with the court order, to go ahead and get stamped. Now, what we started the show off discussing, where there's a new ban on any traveler who doesn't have proof of the vaccination. That's another caveat. So the first ban is just basically about the stamp, receiving the stamp, at the local consulate or embassy. And then, the second one is the actual entrance into the United States. So, it is something that we have to monitor, and it's just another hoop that we have to jump through with all these requirements.
Okay. You said it's a vaccination. That is the very important between the two countries. I'm not sure the United States or whatever approved the vaccination, not exactly the Indian government. Let's say if any traveler took a vaccination from India, which is approved by Indian government, what is the proof we need to show to the travel while taking the on board?
Well, you see, that's a very good question. I don't know all the specifics yet. Obviously, you would have proof of vaccination would be some type of record. Usually they'll give you a card, or you would be registered in a database that you could upload. I know, right now, if you were to travel back home, to go to India, you have to show that you're COVID negative. So you have to upload that as an itinerary with the airlines or with the embassy here prior to travel. So there's probably something like that. Another important, issue we need to highlight is the two existing vaccines here in the United States. I believe the technology is mRNA, which allows, it's not so much of a traditional vaccine in the sense as it is, it's a newer style of vaccine. So, what vaccine is India developing? Is it the same technology? Is it the same strength? Is it are we talking apples to apples, or is there going to be even more prolonged travel ban because people aren't able to get the same vaccine that the United States recognizes as being a viable vaccine? So we have a lot of these issues that are going to be coming up that we need to see how the government's going to address this, and how long this requirement is going to be extended.
Okay. So the second question is still it means almost 6 to 7 months the conflict is not open. It means it giving only the emergency the visas for H4 or family. Most of I see the H4s. Do you have any information these days are open for the H1, L1, and the business visas?
Yes. So like what we were saying a minute ago, if your petitioning company is a member of the U.S. Chamber of Commerce, there's been a court order, within the past 6 weeks that allows members of that Chamber of Commerce to have their employees be exempt from this presidential proclamation. So there are, certain things we can do. And like I've always said on all the shows we've done, we always want to look at everyone's case as a unique case. So, the petitioning organization might qualify, the beneficiary or the employee might qualify based upon, working with some database that helps manage, supply chain management or something like this with COVID vaccinations or some other healthcare requirement. We can work out and try and get, some of these exemptions, passed through so they can get stamped.
Okay. So you already spoke about the new ladder system 2022 Cap. Mm-hmm. So even we don't have much, as you said, we don't have much information which process going to be implemented. All right. So as your experience, what do you think? Maybe USCIS might be implemented some XYZ process. If you expect, just to give me some more information so that we can just for awareness.
Well, to back up a little bit and give everyone an overall picture of what's happening. Okay, so Trump, and we're focused right now, our conversation on H1s, GC, things like this, H4. Overall to the entire system, asylum, TPS, temporary protected status, deferred action for childhood arrivals, DACA, and other programs, diversity visas. Trump has done a lot to change how these visas function and limiting people to have access to this. Even going to immigration court, they've changed a lot of rules. So here at the last days of his presidency and last weeks, he's been just throwing all these rules and changes out as fast as he can. Most of the time, it's a violation of the rulemaking procedures that are put in place under the Administrative Procedures Act. But there's some like this H1b Cap rule that followed the rules. And so it has become a final rule. Now, why this is so important is the new president, who might have the opposite view of what this rule's intended effect might be, he or she just can't go and change the rule. It has to go back through the rulemaking process. It has to have a valid reason to change. And, we have to go through that process, or Congress could just, write a law and change the law itself to change this. So to give you an idea, there's been so many changes and so much damage done that it is going to take the new administration, probably a few weeks or months to to understand what's happened and what's changed. So Since this requirement with the new rule would more or less require the employers to file the cap cases like we have in the past, where every person we file, we have to print out all the evidence, file the LCA, and then let it be selected. Since we use the new system, there might not be, enough time to integrate the new system to accommodate this new bidding process, so to speak, for cap selection. So, I really believe that more likely than not, we're going to be able to sidestep this rule this year, and we'll be able to still use a traditional random selection in the lottery process. Also, a key caveat is this rule does not change the selection process for master's cap versus regular cap. So that's still going to remain the same moving forward. But, there is a lot of changes, and it is going to take the administration some time to understand what has happened, what is happening, and what they can do to change what will be happening. So it's a lot of things at one time.
Okay. So by this new rule, highest wage level, so we already discussed the last session. If you give some more information, how they can select petitions, applications. So we have the level 4, level 3, level 2, level 1. Can you give the more information? At the same time, OFC data is a wage level is a different, the number depending on the cities and tier 1, tier 2 cities. So if go for the wage level, how the USCIS will decide the petitioner in the same category? Maybe California is a higher wages, but not in Austin, Houston, or maybe second levels of cities. Can you give the more information on this one? And maybe you can elaborate how USCIS going to be too.
So yeah, that's a really good point. And just to draw into context, and is a simple method of showing how this is not going to work. We have someone that most of our audience would understand. They're software developers, okay? And let's just use the software developer SOC code 151132, okay? Based upon the Occupational Outlook Handbook and ONET, with all the data that's there, it says a bachelor's degree is typically required for entrance into that occupation. So if you have a bachelor's degree with little or no experience, that would have you at wage level 1 on that position. If you require a master's degree for that position, it would require wage level 2. If you supervise people, it would go up a wage level, et cetera, et cetera. Now, if you are comparing who gets paid the most for level of education, let's say that you're also an engineer, but a civil engineer, okay? Typically, civil engineers almost always require, 100% they have to have a bachelor's degree. And then on top of that, some require a master's degree, depending on the certification, licensure, and things like this. So one engineer is not always equal to a different engineer, right? For software developers, you're not required to get a license. For civil engineers, usually you're required to have a license. Let's say also that I want to hire an attorney on H1b. Well, an attorney requires an advanced degree beyond bachelor's. So a Juris Doctorate degree is a doctorate degree. And so if I start out as an attorney with little to no experience, my wage level is still going to be wage level 1, even though I have a higher degree. So on its face, you can see the challenges about this. So is it just someone who has a bachelor's degree? Is it a bachelor's degree with, also a state licensure? Is it an advanced degree that's usually required to perform the duties in that field? So just looking at that alone to get to the baseline to determine what the wage levels are, you have a lot of disparity with, requirements of what needs to be done for the job. So just alone looking at it from there, it's an unfair system, it's arbitrary, and it's something that probably, I think would be easily challenged in court. The problem would be the timing of everything. Is there enough time between now and March to have something done? And that's something I really don't know the answer to. And we would have to wait and see kind of how things move, what the administration, states, and how things start after the 20th of January.
I think this is a very, it means we need to discuss a very broader way because of the level of complexity in wages, the segment, because the H1, it fall the engineers, all engineers, the software engineers, civil engineers, mechanical engineers, and at the same time, other department kind of healthcare, doctors, right? Maybe doctors also, it fall into the same segment if they want to apply in H1. So here we have a question from Vishnu Vardhan is asking that, let's say if any applicant have the master plus 2 years of experience in a specific segment in machine learning engineer, this will comes under L2 or L3. Or if I want to, yes, Lucas.
So thanks for the question, Vishal. What we look at when we determine wage levels is not so much your own background or your own expertise, what's on your CV. We look at what the position requires. So it's just like if you look at on DICE or anywhere else and you're looking for a position, it's going to list the requirements. So if you're like a ServiceNow developer, DevOps engineer, you need to have this much knowledge. You need to understand, database management. You have to have, whatever it might be. The requirements are there with the minimum education level that usually they'll say you need a bachelor's degree, and then however many years of experience. That data or that information is what we use to determine the appropriate wage level, not so much what your CV reflects, if that makes sense. So that's another reason why this process would be arbitrary, is because if I have a fresher coming out of school with a master's and like 1 year experience, how can I legally list a wage level 4 whenever that person obviously doesn't meet the requirements of what wage level 4 would be? So it's a huge problem. And, a lot of people assume that a wage level 4 reflects the person who's working on the job individually. But in fact, the wage levels in the SOC code is directly about the position itself. So it doesn't matter if one person works in the position or 10 people, that the position and the requirements in that position are what determine the appropriate wage levels to be assigned.
Okay. So it means by this new rule, who will affect for apply for the new H1? Mostly.
It'll be for the lottery. It's not going to be so if I'm going for if I need an extension myself, I'm already cap exempt, then it's not going to apply to me. It's basically going to be people coming in to the H1b process fresh. So basically anyone who currently has H1b or is maybe in a different status, but cap exempt because they previously had one in the past, it's nothing to worry about for them. It's basically people who are in F1 status, the OPTs, CPTs, STEM OPTs. Those are primarily the people that would be affected with this.
Okay. Let's say the new rule is going to be implemented, and the USCIS got 65,000 petition from the level 4. So we'll get a chance to L3 and L4, or how does it work?
Well, I don't know specifically how they would administer that because obviously we just discussed in the beginning the order of selection with masters versus regular cap is still going to remain the same. So masters preference would go first, and then and then the remaining. But the issue is how can they do a process that's not arbitrary. And I think that's the key idea behind this, is that the selection process here is not fair. It's not a blind lottery like what's been in the past, which would be a fair way of processing the visas with a limited quantity. Here, they're more or less evaluating and judging people. So now, is it not just like what you mentioned? How do you determine if everyone's level 4? I mean, are they going to start looking and say, well, a doctor is more important than an engineer, and an engineer is more important than a civil engineer? I mean, how do we determine this, and how far down does the rabbit hole will this go, affecting all the H1Bs? That's why I really feel pretty confident that at least this year, I think we're going to be able to steer clear of any issues with this,
Okay. So I think this is the Trump is brought again. This is already IFR interim final rule on which was about to implement on October 6th, but the courts are suspended those one. Again, the Trump is trying to enforce this new rule. So is there any chance to any law firm go to the court and get maybe is there any chance to stop this new rule to implement? Or
so in the past with the IFR rules, what has made those lawsuits successful is the challenge that the process wasn't fair, the way the government addressed everything. So the courts were issuing injunctions and decisions based upon the merits of what possible damage would be there by petitioners or whomever. And so what we're showing is that there's potential harm, the rules weren't followed, and that we should have a pause or an injunction pending the hearing the merits of the case. When the rules are followed, like they were with this rule, that option is not necessarily there. So when we go and file a lawsuit challenging this, we have to show actual harm. We'd have to show actual, other evidence that wouldn't exist until after the cap selection process, if that makes sense. So it's a matter of the way the government did the rule and how legally we would be able to challenge. So under the IFR, the lawsuits were able to proceed because the government did not follow the rules, and we could show that there was harm. Since the government followed the rules on this case, on this rule, we would have to wait till there's actual harm and then challenge it from there.
okay. So I think we can get more information by next week, or maybe after a couple of weeks, to what is the take on then maybe Biden new administration or maybe USCIS new staff. So we can go for the next question. What is the current situation in H1 exemption cap H1? Do you see any issues or any denials? Is any complicated RFEs recently, or everyone getting 3 years extension, or still getting only the 1 year, 2 years? Or what did you observe last couple of months?
Everything's still, trending in a positive direction with that. We're still getting 3-year extensions. The additional requirements for employer-employee relationship, third-party outside employment are all still, not required. They were, from the IT Serve lawsuit settlement. So, overall, I think what we're looking at is, obviously maintaining status, education evaluations, things like that, to make sure that we have, if you have a foreign degree, that we show that we have a evaluation showing you have the equivalent of a U.S. bachelor's degree. But that's pretty much it. Everything else is more or less smooth sailing compared to last year. I do want to mention we have a new president and vice president. And the vice president is, as you know, and probably most of the viewers know, Kamala Harris. She is her mother's from South India in Tamil Nadu, And she's already, obviously she's born here, but she has tied, to her parents were immigrants, and she's already made a statement, I think today, that they're already starting their agenda looking at how they can fix a lot of these backlogs, fix a lot of the court cases, help people who are in need. And I think, just like how we've heard about the vaccination protocols, how we start out with certain groups, frontline workers, elderly people, and it goes down and down in tiers. I think what they've addressed at the beginning is they're wanting to talk about people who are in temporary protected status to help them through the GC process, the DACA recipients, and to help alleviate the backlog with immigration courts. And I think that's what I would call tier one. And I think tier two is going to include getting rid of this backlog for employment based. And I think that like I was saying for the past few months, I really believe that that's on the agenda. And even if we filed adjustments here this, in October or November, there is a good chance that the clock could speed up and the backlogs could be, moved, to the point where we don't have one, and everyone, hopefully can transition from H1 to GEC, in a short period of time.
Okay. Lucas, we got another question from YouTube, Vishnuvardhan. I mean, are there any lawsuits filed on the lottery system? I think we already spoke about this one. Maybe you can give the one small answer.
So, no lawsuits at the moment. This lawsuit's going to require us, to wait until something happens. Now, there's still a possibility we're not going to have the system impact us this year. So, touch wood, I think the best thing to do would be if we could keep the old system that's not integrated with needing an LCA to be filed. And then that leaves us the rest of the year more or less to have some type of either lawsuit or for Congress to address this issue, this rule, and make sure it's not, there for the future.
Thanks, Vishnu, for your questions. So, Lucas, we can go for next segment is the H4. H4 is a hot topic recent months. Do you have any updates about the applications, approvals, or EAD approvals, or biometric? Even biometrics are getting delays. Do you have any information on that one?
Well, this has been a very difficult year for H4, about probably a year and a half. When it first started with the biometrics requirement, there was delay, and we would, instead of receiving approval within 2 weeks to 6 weeks, depending on, how fast, if premium was used with the principal H1b visa holder, we would see it in a traditional way, kind of going longer and longer based upon the availability of biometrics appointments and things like this. And now when you add this pandemic, with all these appointments canceled, having to be rescheduled, we're getting extreme delays right now in approvals, up to 6-7 months in some circumstances. And a lot of that, the delay is based upon where you live. So if you live here in Dallas, where I am, there's a large population that depend on these visas, and there's only so many offices, so many appointments. Now, if you live in Omaha, Nebraska, or Oklahoma City, there's fewer people, and there's the appointments might be more abundant based upon where you live. So it might, help the processing time with that because there's fewer people in line, and you get the biometrics completed sooner.
Okay. So the recent issues, the same biometric is the one step is hurdling the H4 process.
Mm-hmm.
So what do you think in Biden administration will remove or still remain biometric?
I think we discussed, in the past, I think the administration has to do an honest review of what is important for the safety and welfare of the American people, number one, and number two, how many criminals or what purpose for doing this extra fees or the extra expense is there. So we have to do a cost benefit analysis with the new administration. And part of that is also going to be looking at these fees. Recently USCIS had the permission from Congress to increase the fees from $1,440 to $2,500. What is the real budgeting concerns for this? Is that necessary? Is it unnecessary? And that's something that will need to be reviewed, is how, and also right now there's been quite a few additional site visits, just random site visits and by the FDNS. And, how much of a burden is that on the budget and everything else, and on processing of these non-immigrant visas? So that everything has to have a cost benefit to it. And if this is a wasted process or a wasted step, hopefully the administration can determine that, and we go back to the way things were, where you didn't have to have biometrics done.
Okay. Lucas, about the H4 biometric here, I have one point. Maybe you can give the appropriate direction about this question. Let's say if I spoke local senator, congressman, or senator or congressman, hey, the H4 biometric the process is a long waiting process to get the EAD. If we explain our pain to the local senator and congressman, if they had if they have a discussion with the Biden administration, what real pain in H4 EADs, this will can we do like this to avoid the biometric in H4 process, or what do you think, or your suggestion on this one?
Well, 100%.
Can we approach to the senator or congressman, local senator and congressman, or just your point of view?
100%. That's part of what their role and responsibility is to serve the constituency. So they want that feedback, and they want to know this. And we have a saying here in the United States, the squeaky wheel gets the grease. So if we have enough people mentioning this, or enough people talking about the backlog, please help reduce the backlog, please help reduce the wait times, that will help address the issue. Additionally, they have every congressman and senator, they have liaison office that will help if your case has been exceeding normal processing times, or there's some other issue. They'll reach out on your behalf and try and help and see if there's any issues that they can help with to speed the process up. So it is a resource we use quite a bit, and the resource is there for everyone. And people shouldn't be afraid to reach out for help, because we want things to run smooth. We want things to you pay these fees, you should be able to receive the benefits you're seeking if you qualify for them, and it shouldn't be delayed by months at a time.
Okay. There is a chance if we talk to senator and congressman, there is a chance to speed up, or maybe they can bring to Biden new administration, or maybe USCIS, right? So that's a good news, actually. So, Lucas, we can go for the next segment as green card. So green card, first we talk about the I-140.
Mm-hmm.
We discussed a lot of things about the higher wages for the perm H1 application. And also the higher wages will apply for the perm green card also. So already we discussed what are the steps and how we can apply based on wage levels or levels, level 4 to level 3. How does apply for the green card? The same way, level 4, level 3, level 1, level 2, level 1, or how does apply to green card?
So it's a very good question. So there's a caveat here. When we apply for green card, we have to request a prevailing wage from the Department of Labor. And there's an officer who reviews our job description, our education requirements, and any other special skills, supervisory duties like this, and they'll determine the appropriate SOC code and wage level. Now we can, if we get something we don't agree with, we can always ask for redetermination. And that's more or less, there's a way of doing it where we can always determine, what the wage level should be based upon how we make the request based upon the position. When we file LCAs, there's just so many LCAs to be filed for H1s that in the past, you could always request a prevailing wage determination. And that's what you had to do in the beginning, in fact. But there were so many people requesting this, and the delays were so long that it was not practical for that to work. So the employers, the petitioners, have the ability to choose the appropriate wage level and SOC code using the correct methods of why they're selecting those SOC codes, not to pay the least or to pay the most, but to have it really reflect what the position requirements are. And so that's the two main differences with that, if that makes sense.
Okay. So about green card, the 485 October applications, do you have any updates on the one? All or get the receipt who applied in October month, or?
I've been getting all the receipts. It's been no issue, just like we discussed last October. There's no need to have been, using I think a lot of people were talking about using the same labor that was originally filed for downgrades and all that. That's completely not true. So, other than that, all the receipts are coming in. I have heard from other people, not anyone that we filed a case for, but I think there was some rejections for family members where, let's say you didn't select that it was an I-140 employment-based petition on the adjustment of status, that would be rejected. So we might have a few viewers out there right now that might have experienced that. You should be able to refile, and not lose the opportunity. But that's more of a case-by-case basis. If it has happened to anyone who's watching right now, then please, reach out to Venkat or myself, and we could try and help resolve that issue for you.
Okay, yeah. Maybe if you have any 485 adjustment of status application issues, maybe you can reach out to info@bgimm law. You can send an email to bgimm@law.com. Lucas, what is the interesting point? I got notice. It means I got a couple of the question. One application have the primary application and primary applicant and spouse and kid. The primary applicant and spouse got the receipt, but not kid. So what is the reason did not get for the kid?
Well, it could be just delayed, and that's probably more or less what the issue is. And you have to remember, so all these applications go through Lockbox, and we're looking at Lockbox to make sure that the packages are complete. Money orders or checks are appropriately affixed to the applications with the correct amounts, and then everything's scanned and processed to go on to the officer. So at that time when that happens, the receipts are processed and submitted. Depending on the age of the kids, maybe there's not a requirement, for the receipt at that time, or maybe to not have biometrics, depending on the age. So there's a lot of factors that could, be involved with this. But in fact, the receipt would just be delayed. But we should expect to have all the receipts issued within a standard amount of time.
Okay. Everyone thought is we applying the one single bundle, right? If primary applicant got the receipt, the all applicants should be get the receipt. That's why little it means little confusion and a little worried why kid did not get the receipt number.
It's not always the same. So we're looking at each package, even if it's a family unit, each package in itself is its own filing. So we always want to make sure that even though we file everything together, that we keep in mind that each application is its own case.
Okay. And let's say if any applicant received the receipt by December 31st or January 1st, though when can he expect the biometric? Within one or 2 weeks, or how much time it will take for the biometric?
It really depends on where you're located. So I know, Venkat, you're in Houston, and Houston probably has, out of 4 million people, I'm sure a large percentage of those 4 million are immigrants themselves and probably have some reliance on getting biometrics. So the appointments, wait time for Houston would be very long. Probably the same as if you're in Los Angeles, or if you're in Dallas or Florida, Miami, Florida. There's long lines because there's so many people using the system. If you go to like Wichita, Kansas, you might get an appointment within 2 weeks after getting your receipt. So it really just goes. It's a first in, first out process, or FIFO, and it really depends on where you live and what's the local biometrics facility.
Okay. So now the time is everyone getting receipts. October applicant 485, maybe the receipts. Maybe sooner, maybe next couple of months, or maybe after 6 months, everyone get authorization card and advance payroll, right?
Mm-hmm.
So it means what I hear is until we get the advance payroll document, approved document, we should not travel to outside of United States, right? So
Correct.
what if any emergency? So can you give them more information on that one?
Correct. So the rule is this: you should stay in the United States till you receive advance parole. Now, having said that, obviously we're living in a pandemic at the moment. I know I've been involved with quite a few people who've had parents who are sick, or who have parents who have expired, and it's a difficult time. And obviously you have to go be there with family and take care of that situation. When we have extraordinary events like this, it's not an automatic denial if you leave and come back. It's something we could probably address because it's, but it is a case-by-case basis. It's not a guarantee for anyone. And that's something that we should, make sure we remember. But for the most part, if you do depart for any reason, it's kind of looked upon as abandoning the process, and they could reject or deny your adjustment of status at that point.
Okay. So in this case, we need to, maybe you said it's a case by case, we need to contact to the attorney and take the necessary steps to process here.
Correct. And so we have another layer of difficulty now. So let's say the person who has GC pending doesn't have advanced parole yet. Well, they go home and they're going to need to make sure they have a valid stamp to come back in. Well, right now, maybe they can't get stamped, or the drop box is not available for them. Then also maybe we have another caveat where that you need a vaccination for COVID. Well, maybe you can't get vaccination for some time. So there's a lot of additional issues where in the past, maybe you're gone for 2 weeks for a family emergency, or 3 weeks. Now that could be 3 months, you see. So there's a whole nother complexity here with the time, how far you're outside the country, when you come back in. They can cause obviously difficulty with the processing of the case.
Okay. So one question, Lucas, about this downgraded EB2 to EB3. So we applied again the I-140.
Mm-hmm.
The question is, will we get the EAD and advanced payroll even I-140 in process, under process?
Correct. You what you're referring to is if you file the application concurrently with I-140. So obviously, as soon as the adjustment of status application is filed, uh, the EAD and the advanced parole are also in process. So even if there's an issue with I-140, until the adjustment of status application is denied or rejected or whatever reason, um, you'll still be able to get EAD and advanced parole regardless of whatever happens with I-140. Now, obviously, if I-140 is denied, your adjustment's going to be denied as well. But it's not always all within the same. It's not all the same case processing at the same time. If that makes
Yeah,
sense.
yeah. Here one scenario. Let's say the recently EB3 got December 31st, 2000, maybe January 1st to 2015, right? So if any person applied the priority date of December 24, 2015 is downgraded to the EB2 to EB3, he applied, right? For some reason, I-140 got denied, but 485 is still under process. It means we don't get any final action date, right? In this scenario, that applicant will get the EAD or advanced payroll.
Well, it'll probably still be in process, but usually the adjustment will get an RFE or denial letter too, uh, based upon the fact that the I-140 was denied. It's just not going to happen at the exact same time. So I-140 will be in process once the decision or whatever happens to it's made. Usually it's about another 4 weeks or so before the adjustment application uh, gets a denial or whatnot. So as soon as the adjustment's denied, even if your card says it's valid till 2022, they'll if it's denied, then you lose that benefit, right?
Okay. Then it means even I-114 process, we will get the EAD, right?
Yeah. So as long as the adjustment's filed and it's pending, and what pending means is obviously you don't have final action dates. So the adjustment's pending based upon your I-140. So let's say I-140 takes a year for it to be processed and approved. Well, since your adjustment's pending and it was filed, you have the ability to get EAD and advanced parole, and that comes in a 1-year increment. So the following year, you get a chance to renew. And hopefully this year, we don't have to renew so many times, and they address the backlog so we can finalize these GCs. But, I've known of people waiting 2 or 3, 4 years renewing every year because the dates retrogress and move and go back, go forward, go back. So there are some odd scenarios where that happens.
Okay. Okay. Yes, Lucas, we about to reach. Maybe we have the 5 minutes time. You can share if you want anything we missed, or maybe if you want to share any additional information on immigration system on current Trump administration or Biden administration. Just you can share.
I think you had a very excellent point earlier about contacting representatives and congressmen. And senators. Now would be a wonderful time for people to maybe reach out and say, I've been here on H1b visa for 10 years. I just now recently filed for green card. There's a backlog. It looks like it's going to be another 3 or 4 years before I even get a chance for this process. I might have a kid. The kid might age out. What can we do to address these problems? And if we have enough people from, this point of view in the employment-based backlog, if we have enough people reaching out and maybe discussing this with the Congress person and the senator, maybe that will help move the needle whenever it comes time for Congress to do something, or for the administration to do something, that we have enough input to fix the problem. And that's what I would recommend and request that everyone, do is to everyone work together and let the local representative know these issues. And also there's 2 state senators for every state. I'm sorry, 2 senators for every state. We want to make sure they know as well.
Okay. Yeah, thank you, Lucas, today's session. And you've given a lot of information about the Trump administration and new coming, the Biden administration. Hopefully, the new Biden administration will take a smooth process on H1 immigration and green card process. As we're discussing from a couple of months ago about the green card, maybe he will brought the new comprehensive bill and get clear on long waiting green card process. At the same time, H1 is a very toughest part in highly wages lottery system. Maybe Biden administration will take action and get simplified, and everyone get the H1 application. Everyone will fall into the H1 application system. We'll see the next couple of weeks. So thank you, Lucas, and thanks joining today. Who watching or who posted the questions. Please join every Wednesday 6 p.m. Central Time on Telugu NRI Radio. Get more information on the immigration system. These are we are discrimination. This is not final answers. Maybe just we are trying to bring this information to awareness to the community. Don't take on this final point or final decision making. If you have any complicated issues, or if you have any maybe if you want any information, just reach out to us. We can give the more information. We can guide you the right direction, and we are ready to help the community. You can reach out to the Burgos and Garrison law firm, or you can send an email to the info@bgimmlaw.com, or you can email to the info@telugu-nri-radio@gmail.com. Please tune every Wednesday 6 p.m. on YouTube channel, Telugu NRI YouTube channel, or Telugu NRI Radio Facebook, and get more information on immigration, the current immigration and future immigration questions or topics. You can post your questions, or you can post your topic on Facebook page, and we can ready to discuss, or we are ready to help to you. Thank you, Lucas. Thanks for joining today. Thanks, everyone. Thank you very much today's session. We will catch next week. Until bye bye. Thank you. Good evening. Good night.